Hey, good afternoon, everyone. This is Charles Dobbins. I am the founder of the Multifamily Investing Academy and the principal attorney at Dobbins Law. I want to welcome you all here to the Multifamily Investing Academy's Masterclass Elite Group Coaching Call. This particular topic is one that I've been waiting to do for a while, and now I've got it all set up, and we're going to have a great discussion today. But before I introduce our speaker, let me just kind of run through, as I always do, some of the housekeeping. As I always say, here we go. I'm a lawyer. I'm not your lawyer. Get a lawyer. As you know, for many of you in the Owners Forum, I am now really getting actively involved in helping you get those deals moving. I'm reviewing your letters of intent. I'm helping you through the purchase and sale contracts. We're helping you get the earnest money deposits, all the things it takes in order to get a deal closed. But I am not acting as your attorney. I'm acting as your consultant, and I am going to tell you that you need to have local representation in any jurisdiction that you're buying property in. We just saw that the other day. As a matter of fact, in one particular client's deal, that the naming of the seller became very, very convoluted, and there was just no way. And this is why I state for everyone that I'm not your attorney. There is no way I would be able to help her through that morass, because you really needed somebody with boots on the ground in her jurisdiction in order to solve those problems regarding the entities that own the property that she's buying. So that's a perfect case in point as to why you need to have local counsel. So, all right, today's topic, as you've seen, is working with a securities attorney in your multifamily business. Folks, I've done this. I've done it the right way. I've done it the wrong way. Even though I am an attorney, and I think that actually held me to a different standard according to the Securities and Exchange Commission, I can tell you that securities law is one that you just don't want to mess around with. You need an expert. You need somebody that knows exactly what they're doing. Don't try to get someone who is doing it part-time. So today I'm very honored to have with us Kim Taylor. I'm gonna read her little bio here, and then I'm going to give a little personal anecdote. And so the Florida, and Kim is a Florida and California securities attorney. She is a partner in the law firm of Trowbridge, Taylor, and Sidoti. Now, you might recognize the name Gene Trowbridge. He is the go-to guy. He actually wrote the book on the securities law that everybody should have on their desk as it relates to having a primer for securities law. It is not a replacement for an attorney, but it's definitely the type of book that you need to have on your desk. That law firm, Trowbridge, Taylor, and Sidoti, specifically focuses in securities law for real estate syndications and the small business startups. Kim has been a columnist in the Personal Real Estate Investor magazine, as well as a guest speaker on radio talk shows and at real estate investing seminars and at clubs where she teaches the basic securities laws and how to develop the effective investor relationships, which is something that we will be talking about at the end of this conversation, that is so critical that it's something that we need to put forth and make sure you understand. Her upcoming book is Syndication Simplified. I want to hear more about that through the course of the conversation. And with her law partners, Kim educates, advises new and seasoned entrepreneurs regarding the setup, structure, and documents they need to legally raise money from private investors. Now, my anecdotal story regarding Kim is Kim first came to mine and my wife's attention back when we were doing coaching for Lindahl's organization. Kim was a student and actually selected my wife to be her coach. And my wife, just the other day, I said, hey, I'm going to be speaking to Kim Taylor. She goes, oh, tell her I said hi. I remember the conversations I used to have with Kim. She was so smart. The conversations were going far longer than they were supposed to, and we were just talking about some really interesting stuff in the multifamily arena. But my anecdote with Kim is, you can tell somebody's character by what they do when it's the darkest day. And, when we were going through our problems with the SEC that all of you can read about on any one of my web pages, it was really a bad period. But You know, Kim picked up the phone and called my wife and just offered her support. And that, to this day, has meant so much to us. And that kind of gives you an idea of the type of person that Kim is. So, Kim, are you there? Boy, I hope so.
I'm here.
Hi, Kim. Hi, how are you?
I'm great. I'm great.
Good.
Charles.
Hi. Can you speak up just a little bit more? I want to make sure we get a good recording here.
Yeah. Is
Okay.
this better?
Yeah. Okay, so let's see. I am Kim and I, in anticipation of this call, we talked about a couple of questions, and I wanted to write down those questions that I get most often in my practice, and I want her to explain it and educate everybody as to the right ways to do this. So, and then also, if you have any questions of your own, please type them into the question box. That's why we have Kim here. We're gonna get through everyone's questions through the course of the day. So this is how we're gonna lay it out here. As I just said, if you have any questions, please type them into the questions box, and it should be located in the bottom right-hand side of your screen. Now, Kim, basic question. What is a security?
Well, when dealing in the real estate investment context, we most often run into two things. And the first one is promissory notes, and the second is something called an investment contract. And so the investment, everybody I think knows what a promissory note is, and I think most people are surprised to find out that those are actually securities, but they are. The second thing, the investment contract, is something that has been defined in a U.S. Supreme Court case from 1946. And in that case, the U.S. Supreme Court decided what the elements were of an investment contract. And so if you look at the definition of securities in any state or federal law, you'll see both this term investment contract, and then the very first thing you usually see, the very first thing on the list, is usually the promissory note. So the investment contract is then defined as an investment of money in a common enterprise with an expectation of profit based solely on the efforts of the promoter. So I'll say it again. It's an investment of money in a common enterprise with an expectation of profits based solely on the efforts of the promoter. Well, who's the promoter? Well, that's the person that has the investment opportunity and needs the money. And, you know, in plain English, what does that mean? Passive investors. When you're dealing in a situation where your investors are passively investing with you and they're relying on your experience and expertise to go out and make a return on that investment for them, then you've created a security.
Okay, so in those scenarios where it's you know, two partners, equal partners, they're both bringing, you know, cash and sweat equity to the deal, their membership interest in an LLC would not be construed as a security. Is that what I'm hearing you say?
Yes. So if everybody is actively involved, and when I say actively involved, it has to be more than just a voting right or a right to participate in voting. It really has to be that everybody has a job and that they actually contribute to that investment opportunity more than just their money. So in that scenario, we call those joint ventures. But I almost hesitate to even talk about joint ventures because most of the time people call something a joint venture and then they treat it like a security because the person who had the money really didn't want to have a job. They already have a job. You know, that's how they made the money. And they want you to go out and deal with the investment opportunity on their behalf. So if you're going to engage in joint ventures in order to try to stay out of having to deal with securities laws, then you really have to document how those people participated. Because if they lose their money later on, they're going to have amnesia and they're going to say, oh, I didn't participate,
Right.
He did it all. And you know, now you're going to be found to have engaged in securities and probably didn't follow the right securities law.
You know, it's amazing. You just can't name something else and thereby, you know, flout the laws. It's like your partner one time said in a meeting, you know, if you call a dog's tail a leg, it does not mean the dog has 5 legs. And you know, if you can't just say, well, no, it's not a security. We're doing a joint venture. And I see that so often where people just think, oh, if we call it something else, then we don't have to worry about the securities laws. Now let's go back to the definition.
No, that's absolutely right. In fact, my law partner, Jean, was at a meeting once with the former SEC commissioner, and someone asked the question, how often, when somebody asks you if something is a security, how often do you determine that it is? And he said 95% of the time.
Exactly. Can you give it, with the exception of what I just talked about, what's another example of where it is not a security? What some of these multifamily investors are doing would not be considered a security. Can you think of one?
Yeah, I guess I'm not sure what you're talking about. What's been your experience with that?
Exactly. That's why I always say, even in the example we're going to give in just a moment, I mean, if it's just your brother putting in a deal, okay, who cares who it is? As I found out with the SEC, I have no friends and I have no family. I have to treat everybody as if they're a passive investor, and that's the that's the rule that came out of my book.
Well, I like to use the analogy of driving. I get this question all the time. It's like, hey, if I just have one or two investors, they're just my family, they're just my friends, do I have to? Well, does the law say that if you're driving down the freeway and you only happen to drive once or twice, that you don't have to follow the speed limit? No, you have to follow the speed limit every single time you drive.
Yep.
And the securities laws say that if you are selling securities, you have to follow securities laws or qualify for an exemption. And so if you can't qualify for an exemption because you don't know, you haven't investigated it, chances are you're not going to just be have been found to qualify for an exemption.
Yeah.
You have to consciously go out and seek out those rules and figure out what they are, and then structure your offering to private investors so that it complies.
Right. All right. Next question. Why do we even need to worry about securities laws?
Because, and we just touched on this just a minute ago. So in the 1933 Securities Act was enacted in the wake of the Depression in 1930s, 1929 stock market crash, when there were a whole lot of people that were scamming people with worthless investments. And they were hopping around from state to state, and there was no federal law that could chase after these people, and so they would just go from one state to another and defraud people in multiple states and kind of get off scot-free. So the federal Congress stepped in and said, look, we've got to do something about this. We have to have a way to make it, to enact some penalties for fraud, and also to be able to go after these people that are hopping state lines. So they created the 1933 Securities Act. And in it, they defined what the penalties were and the fact that they could now punish people for violating securities laws. One of the overarching things that came out of that is that if you're going to sell investment opportunities to private investors, you have to provide full disclosure of all material facts necessary for an investor to make informed consent before they invest. And so over the years, that's evolved into providing a written disclosure document, sometimes called an offering circular or private placement memorandum, that talks about the offering and lays out all the facts about who's involved and what the investment opportunity is. But most importantly, there's several pages of risks, all the different things that could go wrong and how an investor could lose their money. If the person who's selling the securities does this adequately in the eyes of the securities agencies, then the burden of loss and the risk of the loss shifts to the investor. If the issuer of these securities and the person who's promoting them does not do that adequately, they bear all the risk of the loss, and then they would be found to have not made a disclosure of all the material facts, and they would probably be accused of engaging in fraudulent activities. So you don't want to do that. So with the 1933 Securities Act, we've got all these penalties, but the Act really said another thing that was of utmost importance, and that is that if you're going to sell securities, so it defined what they were, included those definitions of notes and investment contracts, that if you're going to sell securities, you either have to register the offering or you have to qualify for an exemption. And so the registration process is what people go through in order to do their public offerings. So I'm sure you all heard about Facebook and Google, and even GoDaddy just recently went public, and they did their IPO, or their initial public offering. That's when you go through that registration process, and you file a pile of paperwork with the SEC, and they come back and forth and ask you a bunch more questions, make you provide a bunch more disclosures, put it in their format, and then eventually, maybe 6 months or a year and a half later, they finally say, okay, we deem this appropriate to be able to sell to the public. So once it's been registered, you can sell it to the public. If it hasn't been registered, then the alternative is to qualify for an exemption. And so the federal law has exemptions, but also states have their own securities exemptions. So the state exemptions only come into play if everything is being contained within one state. So if everything is in California, Massachusetts, where the investment opportunity, all of the investors and you are all within that state, then you maybe can go and look and see what kind of securities exemptions Massachusetts has. And if you're going to be crossing state lines, then you'd be want to be looking at the federal law. And the federal law has its own sets of exemptions, that some of which would preempt those state laws and override the state laws, so they couldn't impose further restrictions on you. So you really got to look at these exemptions. Well, these exemptions are not do-nothing exemptions. These exemptions mean you have to figure out what the rules are for that exemption and follow it, just like on a tax deduction. You can take a tax deduction if you qualify for it because you met the criteria for that deduction. The same thing for securities exemptions. They're self-executing. You get to claim that you are following the securities exemption, but if you're ever audited by a securities agency, then you would have to provide the documentation to show how you followed all the rules of that exemption. So that's really what it means. So you either have to register it or qualify for an exemption. If you're qualifying for an exemption, then you've got to understand and follow the rules for that exemption. And that's where you need a securities attorney to help you, because they're going to help you pick the exemption that allows you to do what you want to do, and they're going to explain the rules to you so that you can comply and you can document how you complied in case you're ever challenged.
And 9 times out of 10, the people that you're working with, or the people that are looking to raise money for a real estate transaction, are looking for the exemption type of money raise as opposed to a public offering, correct?
Most of the time. There's been some recent changes in the law, and I think we're going to cover that a little later,
okay.
Where you can actually do a public offering now a little easier than you've been able to before.
Okay, all right. Next question. Here we go. But it's my brother. He'll never sue me. And
it's not the investor, it's the people behind that investor.
Exactly.
So what happens if something happens to that person?
Right.
And now you're dealing with somebody else who doesn't know you, and they only have one objective in mind, and that's to get the money back.
Right. I mean, I always, and I'm sure some of the students on this call right now will say, know that I say it's not your brother that you should be concerned with. It's your brother's widow's second husband that is going to be your problem. And
That's right.
it always never fails that way. So, okay. Next question. At what point in the transaction? Now, understand that we're talking about letters of intent. We have the purchase and sale agreement, and the purchase and sale agreement gets executed. Then we start the due diligence phase with the physical inspection and the financial inspection and legal inspection, and then we decide that we're going to move forward into the the financing period. At what point in that process should we engage a securities attorney?
Well, that's a really great question, and actually Jean and I disagree a little bit on this, but I'm coming from my own experience. As you mentioned, I was a multifamily coaching student of Kate, and while at the same time I was starting this law practice with Jean Trowbridge. So what I learned from my own experience was that you should have a signed purchase and sale agreement. You should have physically been to the site, and you've seen the bullet holes with your own eyes. You've seen the neighborhood, because sometimes it looks great on paper, and you get out of the car and you're like, no way, I don't want to own this. So you've been there. And then the third thing is that you've done the financial due diligence. In my own experience, we had 4 deals that didn't close in 1 year. And in each of those instances, we had done some level of due diligence or some level of investigation. In some cases, we've even been to the site when we made our decision not to go forward. So I think that once you've got those 3 things, you've got the signed purchase and sale agreement, you've physically been to the site, and you have done the financial due diligence, the rest of the deal is pretty much likely to go forward. If you find things during your property inspection or something like that, most likely those are going to become deal negotiation points, but they're not necessarily going to be deal killers. So if you engage us within the first couple of weeks of your due diligence period, ideally we would like to complete the documents we're drafting at the same time as you complete your due diligence, because we're going to take all those documents you're generating from due diligence, your property inspection report, and your surveys, and your photos, and all that stuff, and we're going to attach them to the private placement memorandum as exhibits. So the investor now has all the same information that you have. You've just done the due diligence on their behalf. And now they look at it in the same way you did. They can see everything for themselves as they're making their investment decision.
Excellent. And now, you said that Gene differed than you?
Yeah, Gene usually says, hey, get us involved, when you've got an LOI. But I just know that, so many of these LOIs don't go
Right,
anywhere.
exactly.
And
yep.
sometimes you negotiate the LOI and you can't get past the purchase and sale agreement. There's some sticking point that comes up.
Yeah.
Or you finally get a look at the financials. If you can look at them before you ever even get to that point and get the purchase and sale agreement, fantastic. But sometimes you can't get that information until you've got that signed purchase and sale agreement. So you want to do that first. And when I'm talking about the financials, I mean the last 2 years financial history.
Right, bank statements.
Because that's where you're going to figure out, hey, these people are crazy.
Right.
This is not a 9 cap. This is a 6 cap.
Yeah.
And when you realize all the things, the add backs that they left out, that they don't have management in there, and they've got somebody
right.
living in the apartment for free, that they're counting it as rent, and crazy stuff.
I have to agree with you over Gene's take on it. I mean, just from all the deals I've been involved with, it does get to that point where, why bother at the LOI? The LOI, sometimes you just throw as many LOIs out the door as you can and hope one of them sticks. But it's,
That's right.
it's like, you're waiting for that baby to come to term before you're really going to start to bring in all the other experts. So, yeah, I agree with you. I think you should wait and, save your money as well. Okay, next question. Okay, this is one, and this is, I see this from new investors all the time. Should I do a fund, or should I just do a one-off transaction? Why don't you first give us an explanation as to your definition of a fund and how that operates, and what the difference is from a transactional standpoint between these 2 types of transactions?
Well, there's actually 3 different categories that I like to teach in securities offerings for commercial property. So you've got your specified offering. That's the one-off deal where you've got one property under contract and you're raising money specifically for the down payment and closing costs and your acquisition fee for that specific property. So that's your one-off deal. The second, the alternative to that, or I guess the opposite side of that, is the blind pool or the fund. And that's where you say, I have an idea, and you write a business plan. I actually like to call it an investment summary. So you write this investment summary where you say, I'm going to buy apartments in the southeast U.S. of 100 units plus. So you kind of define the parameters of what you're looking for and what kind of criteria those apartments would have to have in order to get you to buy them. And you go out and you raise money before you have anything under contract. And then the third type is a hybrid of those 2. It's called a semi-specified offering, where you get one under contract, but you also then write an investment summary and say, I'm going to get this one under contract, and then I'm looking for 3 more just like it, or that meet these same parameters that I've defined in my investment summary.
Wow, that is great.
So,
I've never even heard of that before.
Yeah, and I've got an article that I've written about, the difference between these three, so I'd be happy to share those with your students.
Okay, excellent.
So the one-off is going to be a much easier sell for new investors, right? Because your investors are going to want to invest in something they can see, they could drive by, something tangible. The fund is really only going to work for you if you have a track record with these same kinds of properties. So if you've done 4 or 5 or 6 single investor deals, or I mean not single investor, but specified offerings, then at that point you can think about doing a fund where you're going to raise the money in advance, because you're going to have some momentum, you're going to have some credibility, and people are going to be interested in getting into your next deal, and you'll probably have investors starting to be on waiting lists at that point.
The thing I like about this hybrid is it solves 2 problems. First off, it removes the doubt or the risk from the investor's mindset in that they know what they're investing in. They finally get to look and see a deal. But then you can turn around and sell them this hybrid fund under the context that, hey, you like this deal, great. Why don't you get into this deal? And then we're going to diversify your risk with other properties as well. So that if this one doesn't do what we think it is, we can spread the risk over several other properties. And that might be a better, an easier sell for some of the new investors.
Again, I think you're going to have some track record with single deals first, unless you're doing small deals. Okay, if you're doing small, like less than 100 unit apartment complexes, the semi-specified offering might be perfect, because you're just going to define, hey, we're looking for apartment complexes of 50 units or less, and in our defined geographic area. And in that scenario, you're probably going to be dealing with local investors who want to invest in their local community, and they might be willing to invest. And it's too hard to do securities offering documents for when you're raising like less than $500,000, because the cost to actually generate the documents and the time needed to prepare them is going to be prohibitive on those smaller deals. So that might be the way to go on your small deals.
Interesting. Good. Okay, next. I've heard this one guy keep telling me that, hey, they've got this new thing out there called a Reggae. All of my problems are solved. I can even put it up on a billboard and advertise my deal. And I'm thinking about doing just that. So why don't you tell us a little bit more about this new concept of a Reggae and how it's being used?
Well, so Reggae has actually been around for a long time, but it's not been used in the past very well or very much, because it's actually a registered offering. So you're going to go through a public review and approval process with the securities agency. So once you get that approval, you would be able to sell it to anybody. Up until just last month, in March, the limit on a Reggae offering was $5 million. But it costs about twice as much as doing a private securities offering. So no one was doing it. It was too cumbersome. It took about a year to get them approved. The securities agency dragged their feet on them. The only advantage was that once you had one, then you could go out and offer it to the public. The other problem with the old Reg A was that you still had to go through what's called the blue sky review, where you'd have to go to individual states where you wanted to be able to advertise, and you'd have to get their pre-approval, and they all have fees associated with that. So it was just a very cumbersome process. So with the Jobs Act came legislation that said we want to raise the limits on Reg A offerings to $50 million in a 12-month period. So all of a sudden that got people's attention, because it's like, well, okay, now we might be able to do it, it makes sense, and we'll be able to advertise to anybody. So the regulations have been approved by the SEC as of March 25th. We are waiting for those to be published in the Federal Register, and I did check just before the call. They have not yet been published. And then 60 days after they get published in the Federal Register, those regulations will go into effect, and we'll be able to start doing the Reg A offerings. And so there's actually there's two tiers of Reggae. There's something called a Reggae Tier 1, which is kind of like the old $5 million offering, but they raised it to $20 million. And then there's this Reg A Plus, or Tier 2 offering, that allow you to go up to $50 million. But there's going to be some additional requirements on that. You have to do some additional filings. And so it'll be a little bit like a public reporting company, but the ongoing filing requirements are supposed to be less rigorous. Everything is supposed to be filed electronically now, so that's supposed to streamline the process, so it hopefully won't take a year to get those approved. So it could still take several months, though. So this isn't going to be something that you're going to use to raise money for a property you have under contract and you have to close in 90 days. This is going to be something that you would be able to do, again, after you have a track record and doing some of these one-off deals. Then you can think about going out to do a Reg A offering and starting to bring in all these different investors. So the financial qualifications for Reg A investors are different than they are for the private offerings. So historically on the private offering exemptions, there's always some financial qualifications that the investors have to meet. They have to either be accredited, which means they have to have $1 million net worth, or $200,000 income if they're single, $300,000 if they're a couple that files joint income tax returns. So those are some of the exemptions only allow accredited investors. There's some that have some slightly relaxed standards where you could bring in sophisticated investors. So those are people that maybe have been through training programs like yours, Charlie, or maybe like the Lindahl program, or they go to your local RIAs all the time. Something where they have some knowledge and experience and are able to understand these types of offerings.
Hey, Kim, just for the record, my students are a lot more sophisticated than the Lindahl students, okay?
Well, very good. I'm glad to hear
that. And I can say that, based upon fact. So, okay. Now, but what is your, I'm going to ask you a personal opinion. Is this Reg A the solution that all these investors were looking for? I'm not seeing it.
It's, think of it like a college course. That's kind of the graduate level. Right. Once you've done some private offerings, you've raised some money, you've got some track record with multifamily, then you could think about taking your business bigger and going out and starting a multifamily business under a Reg A offering. But the real attraction to the Reg A offerings are that you're going to be able to bring in any investor. You can have accredited investors if you want, but you can also bring in other investors who aren't accredited as long as they don't invest more than 10% of their net worth or their 10% of their annual income, whichever is greater. So that becomes the beauty of it, because now you've got somebody who's making $40,000 a year. Well, I guess they can invest their, $4,000. You got somebody that's making $200,000 a year, they can invest their $20,000. Right. So you've got, or if they have some net worth, maybe you can bump those limits up. But it will open up a wider audience.
But these types of things tend to come down the road after you've got a track record. You put 3 to 5 deals together, and now as a business, you've got to have the cash available to go out there and acquire more properties, and that's when you're going to start looking at these types of offerings.
That's right. I think so.
Okay. All right. Next question. Oh, this one, we did a great discussion on it. We were trying to do a deal using crowdfunding. It didn't work out. But why don't you tell us a little bit about the mechanics of crowdfunding, how this came about, why it's the new buzzword out there, and what types of things we need to look out for.
Okay. Well, crowdfunding is a phenomenon also of the Jobs Act. So it was kind of born out of something that is now called crowdsourcing. Well, have you heard of like Kickstarter or Rocket Hub or some of those kinds of places, right, where they have kind of a reward-based investment strategy, right? So you put out your plea for some funds and to explain what it is that you're raising money for, but you're not offering a return on investment. What you're offering is maybe, if you're raising money for a movie, you're going to give people an advanced screening, or you're raising money to go write a book, you're going to give people a copy of the book, or you're raising money to develop a product, they get the first product.
Right, exactly.
So that's the reward base. That's legal, okay? That's falling outside of these securities laws that I'm talking about. But when you start offering a return on investment, that's where the SEC rules come into play. So the SEC said, well, we should offer something for these small investors, these private investors that are raising money to buy notes or to be hard money lenders, or, these guys that really aren't going out and raising, $1 million at a time. Maybe there should be something for them. So they said, well, if you're only going to raise less than $1 million in a 12-month period, then we should be able to let you take money from anybody as long as they don't invest more than $2,000. So if their risk is small, we'll let you go ahead and advertise for them. But we're going to put some rules on who can take the money, and it's going to have to go through this funding portal, and they're going to be the only ones that can advertise it for you. That funding portal is going to be approved by the SEC or regulated by FINRA as kind of a mini broker-dealer. So that was the original SEC proposed crowdfunding concept in the Jobs Act. That particular section of the Jobs Act has not yet been approved. The current buzz from the SEC is that it's probably going to be stalled until Jobs Act 2 is legislated and authorized, because it has some fatal flaws in how it was written, and FINRA and the SEC can't get together on how they're going to administer these funding portals and how these rules should work. States hate it because they think it's a license to steal, and they think that there's going to be a lot of inept people raising money $2,000 at a time, and it's just going to cause havoc in the marketplace with investors and investor fraud. So you can't do the $1 million offerings right now. But at the same time as that was, the Jobs Act was authorized, there was another part of the Jobs Act that said, but we are going to allow you to advertise offerings if you only include verified accredited investors, because accredited investors should be smart enough to protect themselves. They don't need as much protection. We'll let you go ahead and do that under one of the private offering exemptions. So that's called Regulation D, Rule 506C, like CAT, so 506C. So that allows you to advertise an offering that will only include accredited investors. You can advertise it to anybody, but you have to make sure that everybody that invests is verified either by you or by some third party that has a license, such as a CPA, an attorney, or a registered investment advisor. And it could be that investors own person, or they could go to a third party that you refer them to. But so somebody has to verify it. You've got to document that you have a reasonable assurance that all the people that invest are accredited. And if you do that, then you can advertise those offerings. But the key here is you can't just advertise all the time. You have to have an offering, right? Because if you advertise all the time, you're poisoning the well. Because if you later want to do one of these other private offering exemptions that doesn't allow advertising, now how do you won't ever be able to say that the people that you've met didn't come from your ads. So you can't just go out and say, oh, I'm just going to advertise because I can advertise for accredited investors now, and just start advertising and standing up at your RIA and all of that. Because now if you ever want to do an offering that allows sophisticated investors or doesn't allow advertising, then you would have a hard time being able to include those people.
Interesting. Okay, so are you working with any crowdfunding sources that you could recommend, or, I mean?
Yeah, we've got a couple that we know the principals at, Real Crowd and CrowdStreet.
Okay.
We've actually done a couple of deals with some of our clients in CrowdStreet, and we know the people at Real Crowd.
Excellent. Okay. So
those two are advertising sources. So they'll take those 506D offerings and they will post them on their website for a flat fee, and so it's a marketing fee. They'll promote them out to their list of accredited investors whom they've been developing, and they will attempt to raise part of the money for you. They're usually not going to raise all of the money. They're going to want you to raise some portion of it, probably around half or so. They really want to work with seasoned investors, people that have a track record. So they don't really want to do this if this is your first deal. And then there's a different kind of company out there that also calls themselves crowdfunders. Have you ever heard of Realty Mogul?
Yeah, that's the one we were talking to one time.
Yeah, so Realty Mogul, there's another company, I think iFunding, and their model is a little different. They work through a broker-dealer, so somebody who is actually licensed by FINRA and the SEC, to offer their investment opportunities. But if they like your deal, then they will go out and kind of do a sub-syndicate. So they'll create their own offering. They'll go out and offer it through their broker-dealer, and then they'll come in as a single investor into your deal.
Right.
So slightly different business model. Again, they like to see somebody with some experience and some credibility.
Right.
And but that's a question I get all the time too: is how do you get experience if you don't have it? Well, team with someone who does.
Yeah, exactly. You need that key principle. Everybody needed it. I needed it to get when I got started, and everybody needs it. So. Yeah.
That's right.
Yeah, they don't tell you that in those weekend boot camps, do they? So anyway, all right. Next one. Let's talk about investor relations, and this is crucial. And I know you would mention this in your bio down near the end, but let me just give you my personal experience, and then I want to hear how you handle it. When we were sued by the SEC, 35 of our investors all came together and hired an attorney to represent them. And they hired the attorney to protect their interests against the SEC. And the SEC couldn't understand, well, wait a minute, we're the good guys here. We're the ones that you guys should be, using us to protect yourself. And the fact is the investor said, no, we want you to leave the Dobbinses alone. They're doing a fine job. Let them continue to manage the investments and get out of our way. And it was so interesting that even the judge was surprised that here is the SEC suing a group, and the group of the investors are actually lined up at the door, asking them to be left alone and protected. And it was all because we had done a fantastic job in building investor relations throughout the course of our building of our business. So that is... when I see these guys thinking about getting started with a Reggae by putting an ad on a billboard, those aren't the people you get off a billboard are not the type of people you want to have a relationship with when things go bad. So building strong investor relations is crucial to have a very successful multifamily business. So I will now turn it back over to you, Kim.
Well, I think that you're right, Charlie, and that's really interesting that the investors hired somebody just kind of like, you're being the bully here. You get out of the way. Get off the playground. We're happy to.
Exactly, and if you go on my website and click on it, there's a PDF picture. There's a picture of the letter from the from the Investors Council, stating just that. So this isn't something I'm making up. I actually have the documentation on the website.
Right. Well, your investor relations start with meeting people face to face, getting to know them well enough to know that you want them in your deal, and letting them get to know you well enough to know that they want to invest with you, understanding their financial situation before you make them an offer to make sure that they're even qualified for what you have to offer, and that's going to be defined in the rules for your securities exemption. So you've got to ask the questions, do you meet the criteria for the kinds of things I have to offer? But also talking about what they're looking for and making sure that what you're offering them matches what they're looking for. So quickly we want to jump into, we're just looking for passive investors and that's all we want. And that's not true, because when you're doing one of these multifamily deals, you have lots of opportunities for people to participate with you. And so if you're interviewing them, just to figure out, just think of it like a job interview. Where might you fit into my organization? Because they might know a lot of people with money, and so they could come in as a member of your management team and become a part of the issuing group and actually participate in the management fees and distributions in order to bring in a bunch of their friends into the deal. Okay, so that's one opportunity. Maybe they've got previous business expertise that's going to enhance your credibility. So again, you might be looking at them and bringing them in as part of your management team. You might need to have a loan guarantor, somebody who's got the net worth to support the bank loan and the carve-outs on the bank loans for your your bad boy provisions and your environmental indemnification. So you got to have people for that. And if you can't find that guarantor, you might never get anywhere with your offering, even if you had somebody you could go out and raise all of the money. So you've got to have that.
Right.
So then the other thing obviously is that you could have passive investors, and maybe they could, they're not willing to participate in an equity deal, but maybe they'd loan you some money. Or maybe they'd loan you the money that you need to do, to get the legal fees and the due diligence done. So there's lots of opportunities. So if you're looking at developing relationships with new investors and trying to just determine, like a job interview, where they might fit into your organization, I think you're going to be surprised that there's a lot more opportunity out there than you thought with those people.
Yeah.
So
that's
important.
The use of when you sit down with these investors and find out what their money is good for, and what I mean by that is I tell the story. I've got this earnest money deposit program, and basically what it is hard money lending for the earnest money deposit, and it's all done through contracts and the control of contracts, as opposed to a hard money loan on a single family house, which requires a first mortgage. But the way that whole program came about was because an investor that I sat down with, who had $1 million liquid, and I thought, man, this guy's going to be great. He's going to come right into my investment, and everything will be fine. And he came back and said, no, I'm just looking for 90-day deals. I'm just looking for short-term investments. If you can get me that, then I'll do it all day long. And that's how the earnest money deposit program came about, because we're able to control the contracts, the assignment contract and the purchase and sale contract, and in such a way that we're able to use these investors' dollars in order to put into the deal and make the deal happen. And that came about because we sat down and talked to these investors, and tried to figure out, well, the guy's got $1 million. How can we use that money in our program? And it was a win-win for everybody.
That's right.
Yeah.
That's right. Well, and then the other thing is, once you meet someone and you have those initial interviews, you got to have a system in place for keeping them informed, because you could be looking for deals for 3 to 6 months and never get anything under contract, but you met somebody a long time ago. How are you going to keep them interested in what you're doing? You should have some kind of a newsletter program and a drip system and a customer relations management program where you can keep track of those investors. You can start sending them and feeding them information and keeping them interested in what you're doing, so that when you do have a deal, they still remember you, right? So you can call them up and say, hey, remember we had dinner or lunch or coffee, or and I've been sending you these newsletters. Let's talk about this opportunity now. So you've got to have that.
And it's even telling these investors what deals you didn't do. And we found that to be very effective as well, because it built up our credibility, that we weren't just willing to go out and do any deal. We looked at a bunch of deals and passed on a lot of them. And so when we finally found that one good deal, people were like, oh, okay, I'm ready to go right along with you.
Mm-hmm.
Yeah. So, okay, now,
that's great.
Okay, let's check for questions. If anybody has any questions, you can type it right in the block now. But if you want to get a hold of Kim, here's her contact information. And Kim, you were talking about some articles that you have, and I went through your website. I mean, your new website's fantastic. It's got so much good stuff on there. Are those articles that you're talking about, are those on your website as well?
Most of them are. Some of them are a little newer. They might not be posted quite yet. So I have an article, for instance, on the difference between a Regulation D Rule 506B and a 506C offering. So 506B is kind of the old model where you couldn't advertise, and then the 506C is the one that you can advertise. So I think that one's really relevant right now. I've got this other article on what's the difference between the blind pool or the one-off deals. That I think would be relevant to your students. So
Good.
I think, but feel free to dig around on our website if you want either of those specific articles. Please email me, and I'd be happy to send those to
Excellent.
you. And we do free 30-minute consultations. So if you want to give a call and just talk about where you're at in your business, that would be a good thing. But you really need to call us as soon as you get a property under contract, so we can get you the fee agreement and get you ready, so that as soon as you've done that financial due diligence and you've been to the site, we're ready to hit the ground running. And it takes about 2 to 4 weeks to get your documents done. So, and there's going to be a lot of back and forth during that time. At the same time, you're probably running around crazy trying to do all your due diligence and coordinate that as well.
All right, quick question here from Mike. Now, this is a question that I hear all the time, and I'd love to get your response on it. I'm going to read it to you exactly as he has it typed here. Is it okay to build a list of potential investors through email marketing by not discussing specific deals, but generally talking about what we or our company does?
Yes, and that's a good idea. You can advertise your company. You can always advertise your company, but you have to be very careful when you're advertising your offerings. I would suggest that if you're going to do that, you should engage Securities Counsel to review those marketing materials, so that you're not making claims or doing things that are going to attract the attention of the regulatory agencies. We have a program for that we call our Quick Start Annual Retainer Program. It's $1,000, and it gives you up to 4 hours of legal advice with any one of us. You can pick whichever you want to work with. If you want to work with Jean or Jillian or me, or you can work with any of us. And we'll review your documents. If you want to do a blind pool, because you've got the track record, we'll help you with your investment summary, and we can give you some guidance on what that should include. So it's a really good way to get started, and then if you end up doing an offering with us within the 12-month period of that agreement, we actually credit that $1,000 back to you. And it's a huge discount off our normal hourly rates, which are $425.
I got to just tell you that is a fantastic deal. I'm not sitting here trying to pitch it, or I'm making affiliate commission or anything. That's not the case. To spend $1,000 as an insurance policy, where you can have securities attorneys coming in there and cleaning up your website and making you look professional, and folks, as business owners, and I pretend Kim cover your ears, but as business owners, what you're doing when you do that is you're shifting the liability for the security issues onto an expert. And I'll tell you, that was when we got sued by the SEC. We had attorneys that represented us that put the documents together, and that was our saving grace, is that we did everything the right way, and we were able to show that we went out and hired all the right experts to do it. So this Quick Start program is a great deal. You should really contact Kim about that and get that on board right away. So no hesitation on that whatsoever. So.
Well, and not only that, now you look cool because you got a security.
Oh, is that how you look cool in this business?
Yeah, that's right.
Oh, great. All right, good.
Securities attorney about that.
No, I don't count. Using me to help you get through all the deals, that's not cool. You got to get Kim. You got to hire Kim. So, all right, Kim, that was fantastic. I really appreciate it. I'm so glad that you came on board here. And if any one of my students, any one of my clients needs a securities attorney, Kim's the one to call. So please, here's her information right here. Set up that half-hour conversation and give her a call so that you do everything correctly. And don't wait, and don't try to do this on your own. Please, I beg of you, do not try to do this on your own. So any closing words of wisdom, Kim?
Just get out there and write LOIs, because none of this makes any difference until you get a deal under contract.
Oh my gosh.
You've got to raise money.
Did everybody just hear that? And I didn't even coach her to say that. That's all you got to do. That's the only thing you can control in this business is making offers. You just got to make offers. So, wow. You made me sound like a genius right there, Kim. I appreciate it.
Hey, there you
All
go.
right.
You know?
Hey, I appreciate it, Kim. Have a great day, and I look forward to working with you in the future.
All right, thank you.